Do I need a ladybird deed if the home and assets are in a trust? So the trust and the ladybird deed are essentially trying to accomplish the same thing for real property, and that is to ensure that they don't go through probate, which is a court process that's mandatory when somebody passes away, owning assets only in their name, without a beneficiary, without a joint owner. And this is even if they have a will, right? That court process can be very long sometimes. It's also expensive most of the time, and typically much more expensive than setting up something in advance. So basically, if we're talking about a revocable trust here, one that you can make changes to, you put those in place so that your home, as well as other assets, can avoid probate. Whereas a ladybird deed is a tool that's utilized for real property, real estate, so that it can avoid probate. So if you already have a trust and your home was retitled under the trust, and this is something to make sure that this happened, because oftentimes I'll have people come to my office and tell me, oh yeah, we have a trust, our home doesn't have to go through probate now. However, the attorney who they hired didn't bother to tell them that you have to actually transfer ownership or transfer the title of the home into the name of the trust and out of your name individually, if that's what your goal is, to put it in the trust, right? So I'll look it up and I'll find out that the property is still in their name. So it actually wasn't ever put into the trust. If it's not in the trust, then it's not going to avoid probate, or it's not going to actually fall under the trust. So that's an essential step. It is called trust funding, and it must be done with all of your assets, not just your real property, in order to make sure those assets avoid probate. But assuming in this instance you have a trust, your home is in the trust, so it's the Smith Family Trust under instrument dated August 1st, 2012 as an example, right? So that's that's the trust. That is what's on the title for the home. That's who the entity that owns the home now is your trust, right? So the home should essentially avoid probate, assuming everything was done properly, because it is in your trust. So there would be no need in this instance to also do a ladybird deed. I do want to mention that my office and a lot of other estate planning and elder law offices are big advocates of using ladybird deeds in conjunction with a trust. And what I mean by that is you would have a trust in place, a living trust, revocable trust, that could own all of your assets or be listed as a beneficiary for some of those assets, like bank accounts, investment accounts, money markets, high yield savings, all different types of stocks, bonds, CDs, right? So you would have the trust in place, so you have full coverage on all your assets, so that your assets wouldn't go through probate if they're either owned by the trust or list the trust as a beneficiary. But then for the real property, what you could do is utilize a ladybird deed where you and your spouse stay on the title during your lifetime or lifetimes, and then the property would deposit directly into the trust upon the survivor's passing or the owner's passing. There's a few different reasons that this is preferred. One has to do with homestead, although most counties now do have language that you add into the deed and the trust that preserves the homestead exemption. I'm a big advocate of it for homes where there's a mortgage, because I'm never quite sure what banks are going to do. It shouldn't be that they call a loan due when you transfer property into a revocable trust, but it might be safer just to keep it in your name since the loan is in your name. Also, since title insurance was purchased in your name, most likely when you bought the home, that it's nice to keep it in your name for those purposes as well, because it would you continue having the same title insurance. And definitely for my clients who are 100% disabled as veterans, they get a very large tax break, usually 100% on their property taxes. So we like to leave their names on the deed as well, just to be sure we're not putting that tax exemption at risk at all. And there's other reasons as well, but that's why we'll sometimes utilize a ladybird deed with a trust, making it so that your name stays on the deed, but the property goes into the trust when you pass away. If you didn't do that, it's not something that I feel like you need to freak out about. You know, the property's in the trust. Most likely it is fine, especially if you consulted with an attorney and an attorney put it in the trust. And if it's already there, then you know that you don't need a ladybird deed because you already essentially have the property owned by the trust, and that's what's going to make it avoid probate the same way a ladybird deed would. All right, I hope this answers your question. And if you have any other questions about ladybird deeds or trusts, asset protection, probate, Medicaid, and you're in Florida, don't hesitate to contact our office. We're atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio. Have a good weekend.